The final case of our morning call is Kostadinovski versus Harrington and Advanced Cardiothoracic Surgeons. Also a motion on the application, also 15 minutes.
May it please the court, Michael Cook on behalf of Dr. Stephen Harrington and Advanced Cardiothoracic Surgeons. I do plan to reserve 2 minute time for rebuttal, but I understand that no one's been successful with that so far, and depends on how conversational we get.
I'm betting on you. I think you could do it.
I know that this court's focus isn't necessarily on this case, it's on the next 100 cases and how this one might affect those. So I want to start with some examples of that effect. In particular, how plaintiffs' interpretation of the statute might affect the future cases. Consider a hospital that has agency relationships with an ER doctor, nurses, surgeons, anesthesiologists. Under Kostadinovski's interpretation, a plaintiff can send a notice to the hospital outlining a claim against the surgeon, await the notice period, file a complaint limited to the claim against the surgeon, wait for the hospital to file an answer, and then amend, as of right, into the suit claims involving the ER physician, the nurses, the anesthesiologist. In that situation, the hospital doesn't get the notice that the legislature intended, and it's sent scrambling to mount its defense. Another example, plaintiff sends a notice, outlines a claim. Shortly after that, they discover another claim before filing their complaint. Under Kostadinovski's interpretation, the plaintiff doesn't have to, and frankly shouldn't, send a new notice to that defendant. He should just file his complaint, wait for the answer, and as of right, amend the new theory into the complaint. The defendant doesn't get the notice. Again, he's sent scrambling. In an area where the legislature has recognized the complexity of the claims and the value of advance notice, Kostadinovski's argument encourages ambush tactics. That doesn't reconcile with the statute, particularly because the statute is specific in terms of what it requires of describing the claim the plaintiff wants to assert, the applicable standard of care, how it was breached, and how that breach led to causation. There's one point that I want to address in the briefing in terms of the argument about the exception for when a plaintiff wants to add a new defendant. So there's an exception that shortens the period to 91 days when adding a new defendant, and Mr. Kostadinovski argues that because there's an exception for that, the statute must not apply to adding a new claim against an existing defendant. Well, the 91-day period strikes a balance between those involved in the litigation and those who would join it midstream. With an existing defendant, there's no balance to strike, so there's no exception. There's no need for one because under Subrule 9 of the NOI statute, the defendant has the right to waive the notice period if he doesn't want to exercise his statutory right to 182 days. If he does want to exercise that right, then he gets the same benefit he had before the original notice and claim were sent. The general rule applies. So my basic point for this court is this. The statute doesn't differentiate. If the plaintiff wants to commence an action on the claim, he has to send the statutory notice for it. That didn't happen in this case, so the trial court was right.
Counsel, under your theory, though, you leave out one kind of critical element, the statute of limitations. So, I mean, basically, under your theory, if we were to go on that, you're going to wind up being barred because of the statute.
That's not true, and I want to address that with 2 points. First, here, there's no dispute that this claim would relate back to the original filing if they had sent a notice of intent to sue on it. It does relate back. Under Doyle, the Court of Appeals did this analysis, and we didn't challenge it on appeal. It falls within the same transaction. It's the same injury. It's the same surgery. So here, there wouldn't be a statute of limitations problem for Kostadinovski if he had sent the notice, right? And the second point is there's no difference, really, if you decide to assert this claim after you file the suit, or you decide to assert this claim 3 years and you haven't filed a suit yet, right? If you decide not to sue or you haven't come across your theory yet and you're too late to assert it, the statute of limitations is going to bar it. Whether or not you've sued on another claim really doesn't have bearing on that. So for that reason, I don't see the statute of limitations as having a real impact on the analysis of whether or not you need to send this notice for the new claim.
So I don't completely understand what you're saying. I mean, do you acknowledge that there is, in fact, no statute of limitations problem here? Because as the trial court said, it would relate back to the date that the original notice was filed. Do you agree with that?
Correct.
So the issue is not whether the statute of limitations is going to preclude this lawsuit potentially or not. What is the issue?
The issue is that Mr. Kostadinovski couldn't amend this new theory into his complaint. It was futile for him to do so because he hadn't put it into a notice and sent that notice to Dr. Harrington before he tried to assert it and put it into this case. Fundamentally, my position is not difficult for the plaintiffs to navigate. All they have to do is send a new notice when they discover it. In this case, the plaintiff admitted during the hearing that he actually knew about this theory many months before he actually tried to file and bring it up in a motion to amend his complaint. He knew about it back in July 2015. If he had sent the notice back then, he has no problem, right? He can send the notice, wait the period, and then amend it into his complaint. He didn't do that. So fundamentally, again, I don't think this is going to be a problem for many plaintiffs going forward. It's a problem for Mr. Kostadinovski because he only sent one notice, and it did not include the claim that he now wants to
They've
assert.
argued they don't need to send an amended NOI because they've already filed an NOI, right?
That is their argument.
And they've argued this throughout the process, and the issue hasn't been clearly decided, and presumably or likely it'll be decided in this case, and at that point, is there any reason they shouldn't be allowed to pursue that?
It's too late for him in this case. We got to the point that he should have sent his NOI. We got to the point that we dismissed his pleaded claims with prejudice. They were without merit. And we got to the point that the trial court denied the motion to amend the complaint. For him, it's going to be too late. For future plaintiffs, this court can provide the instruction of how to do this.
So if we hold that they need to file a new complaint, a new notice of intent at this point, it's too late for them to do that.
It's too late.
They alone among all the universe of people who want to amend their complaint or their NOI in substantial ways will be in the cold.
As I believe happens in many cases, yes. Since they decided to take an aggressive tactic, they didn't send an NOI, they wanted to just amend it in. That's unfortunately what happens when some people take the positions that they do.
Mr. Cook, that was my question. This, I'm guessing, is not the first time that this sort of situation has arisen, where there is a new claim or theory that hasn't been alleged in the NOI, and that what is that the typical practice, is to file a new notice? Is it an amendment? I mean, what's the sort of real world reality of how this gets done when you have a new theory against an existing defendant?
So whether or not it's sending a new notice or labeling it amended, I don't know that there's material difference in those 2 points, right? As long as you send something new that gives the defendant a new theory, I think that will comply with the statute. In terms of what plaintiffs actually do or have been doing up to this point, I can't tell you exactly that. My practice is limited to appeals, and I don't really handle the NOI aspect of it. What I can tell you is that with Gully, Reeves, and Decker on the books, I think those convey to plaintiffs that, yes, you do need to send a notice of intent that has this claim in it. Otherwise, you can't put it in the complaint.
Is there a distinction between amending it and filing a new one, where if filing a new one, you have the waiting period that's required, but there is no such requirement if you are allowed to amend it, correct?
Sure. So if you're truly amending the NOI, like happened in the Bush case, right, where there's a defectively described claim, it was in there. They just didn't really lay it out the way the statute requires, and you're amending it in. Then yes, the courts are going to, whatever 182-day period you've waited up to that point is sufficient for the way that you've amended your notice. The difference here, and why I think an entirely new notice needs to be sent, is because it's an entirely new theory, right? And this is probably a pretty good case for this court to address this issue, because there is no dispute that it's an entirely new theory. The first notice had nothing to do with the new theory, and they've admitted that. They actually stipulated to dismiss the pleaded claim, saying, yeah, that has nothing to do with where we want to go now. So when it's something entirely new like that, I don't think you can get into the Bush area of amending it, because it's truly not an amendment. Bush said this is okay because the defendants could tell from this notice where you're going. they can tell what type of claim you're going to assert. That wasn't true here. There's no real amendment to do to this. It's an entirely new theory.
And your theory, I mean, your position is that they didn't even attempt to amend it. In this case, it was a remedy that was provided by the Court of Appeals, even though it had been.
Right, so my real gripe with the Court of Appeals is that it didn't perform appellate review. It brought up a statute that wasn't brought up in the trial court. It reversed the trial court under an abuse of discretion review because it didn't grant relief that the plaintiff didn't ask for based on a statute that the plaintiff didn't cite to it. Fundamentally, I think that's wrong. If you agree with me, I think the result is reverse and reinstate the trial court agreement. If you think the Court of Appeals analysis is actually correct, I still think you need to vacate and reinstate the trial court's order, because in this case, that analysis is wrong because it wasn't raised, preserved, and it's the wrong application of the standard in this case. There are no other questions.
You can reserve.
I will.
See?
Success.
I like to believe in you. Yeah.
Thank you.
Good afternoon. Mark Granzotto on behalf of the plaintiff appellees. And I waive any self-imposed limitation on the questioning by the court. When this case came to my office almost exactly 3 years ago, this was one of the most important cases, medical malpractice cases that I had come across in quite some time. And that's because the defendants made what I consider to be a radical argument in the circuit court. The defendants argued that the plaintiff was foreclosed on the prong of amendments called futility. The plaintiff was foreclosed from amending the complaint to add new theories that were discovered during the course of discovery, unless the plaintiff's claims, the amended claims, were in the original NOI. That was the defendant's position. In other words, you had to, as this court recognized you couldn't in Roberts, you had to, at the very outset, 6 months before you even filed a complaint, you had to anticipate all theories that would be uncovered during the course of discovery and put them into your NOI. That was the defendant's position. That was, in fact, the decision that the trial court made in this case. The trial court ruled that it was futile to allow this amendment because it wasn't in the original NOI. This was, from my perspective, an incredibly dangerous determination, particularly in light of the fact that obviously NOIs are drafted at a very early stage. They are drafted without most of the time all of the documents that you need, even from the records. There's obviously no discovery. And yet the trial court's ruling in this case was that the claims that you could raise in a medical malpractice case were frozen 6 months before you even filed a complaint. That was the ruling.
Mr. Granzotto, can you help with Justice Kavanaugh's question? This must not be the first time this has ever happened that a new claim has been discovered.
Yes.
What normally happens? What's happening?
What normally happens is, the Decker is a good case to look at for this because it happened in Decker. It's happened in my practice multiple times. I make the same arguments I made in this case, okay? And the first argument that I've made is 2912B has no application to an amendment. That's the first argument. It is a rather simple statutory argument, and that is, I came into the courtroom today, and a nice lady passed me a piece of paper to describe what these cases were about today. And she handed me this. And when I got to Kostadinovski, the very first sentence that is in this sheet, I'll consider it binding on the court, perhaps, is pursuant to MCL 600.2912B, quote, a person shall not commence an action alleging medical malpractice against a health professional or health facility unless the person has given the health professional or health facility written notice under this section not less than 182 days before the action is commenced. That's what the statute says. This statute, as this court has recognized in at least 3 or 4 cases, is a pre-suit notice. It is not a mid-suit notice. There is one provision of 2912B that is, in fact, a mid-suit notice. And that provision is 2912B3. And that mid-suit notice says that if you are going to add a new defendant, you must give notice and you must wait 91 days. That's the first argument. The first argument is this statute doesn't apply to amendments.
And that argument is working in most trial courts, am I to assume, or people don't appeal that?
Well, it's every time everybody calls me or hires me on one of these cases, that's the first argument to be made.
Okay, and how does it go?
And it has not done well, surprisingly to me. Decker,
Okay.
I must confess, Decker, if you read it from the lens of a court straining to avoid what they thought was an intolerable result. The fact is that this statute, when you read it simply, okay, and read it the way it's written, doesn't apply to amendments. It is a pre-suit notice. And in fact, the footnote 6 of the Court of Appeals decision in the case rejected this argument based on Decker, okay, because the Court of Appeals in Decker was trying hard to avoid the problems associated with the defendant's original position in this case. And I stress original because the defendant has abandoned that position. You have to understand, Mr. Cook is smarter than the trial lawyers who represented the defendant, and Mr. Cook is not arguing what the trial lawyers argued in this case. Mr. Cook, and this is a strange thing about this case has become less important as it arrived at the Supreme Court. Less important to me because of the concession that Mr. Cook has made. And it's become less important because the defendant has acknowledged, completely unlike the position that the defendant took in the trial court. The defendant's position in the trial court was, you got the original NOI, 6 months, you filed it 6 months before, you got to find your amended claims in there. They got to be there, and if they're not there, it's futile to amend.
So is it fair to say that Mr. Cook's position, as you're saying in the trial court, whether or not it's still here, is that if you don't plead it in the original NOI and are clairvoyant to say this 6 months before you even file suit, that this is the theory, you're out, and your position is all the way on the other side, that's saying, I can file any claim, I can give notice of any theory, and then the whole world is open to me of what comes later, and I don't need to amend it.
I don't want to confuse you. My argument comes in 3 parts.
Okay.
The first one is it doesn't apply to amendments. The second part, we're in agreement on. The second part, that's where Mr. Cook has changed the defendant's position. Because Mr. Cook, as he just got done telling you, takes the position that if you want to amend, file a new NOI. File a new NOI. And what's different, obviously, about this case than all of the other NOI cases in the past, Roberts and Driver, and those other cases, they all involve statute of limitations problems. This one doesn't. This one doesn't because of 2.118D and the relation back rule. There is no statute of limitations problem, which means if Mr. Cook wants me to amend, I can amend. That's easy,
Okay,
and
so
it will relate back. But here's the problem. This is what Mr. Cook's position. If you don't adopt what 2912B says, this is what's going to happen. What's got to happen in these cases, according to Mr. Cook, and I accept as my secondary argument, he's right. Okay, I'll accept it. That's why this case, to me, has less significance in the Supreme Court than it did in the Circuit Court. His position is, if you want to name, you found out during discovery these new theories, all you've got to do is amend, move to amend, and do a new NOI. So here's the process that they are advocating, and you got to understand what you're going to be visiting on trial judges. What has to happen is the plaintiff finds out these new theories. They're nowhere in the NOI because he just found out about them. Okay, the plaintiff has to move to amend their complaint. The defendant says, well, okay, you got to file a new NOI. Okay, the plaintiff can't, he gets the amendment. The trial judge says you can amend the complaint. The amendment is granted, but the plaintiff can't file the amended complaint. The plaintiff has to file an NOI, and the plaintiff has to wait 182 days or 91 days or whatever it is. In fact, this is part of my point here. Because the statute doesn't cover amendments, you got to pick. Some places it says 154, some places it says 181, some places it says 91. Okay, pick. And you can judicially legislate, because you're going to have to if you accept this position of the defendant. But what's got to happen is the plaintiff files a motion to amend, the motion gets granted, okay, no statute of limitations problem, but the plaintiff can't file the amended complaint. Instead, the plaintiff has to ship off a notice of intent. And that notice of intent, once it's served on the defendant, has to put everything in abeyance for 6 months.
Do you
That's
agree
what's going to happen
that
every single time.
the trial court could have, as the Court of Appeals suggested, allowed for an amendment, or could have engaged in that? And I think your position is that whose obligation is it to raise that? Is that your obligation or your client's obligation to say, let me amend it? And maybe, I think there's a difference between saying, I'm trying to amend the NOI. I might not cite the right statute. I might not cite the right case, but I get appellate counsel and they do it better for me. Or is it the trial court's obligation to raise that? Because I was reading you as suggesting that the trial court could have and therefore should have raised that.
People call me. I'll answer it this way. People call me. They say exactly this scenario, because as you suggested, it happens all the time. Okay, I tell them, do what you would normally do, file a motion to amend. If the defendant insists on a notice of intent, okay, and obviously we are talking, please understand, we are talking about an existing defendant. None of this applies, obviously, because relation back is a serious problem if it's not an existing defendant. But if it's an existing defendant, the statute of limitations is no problem. File the motion to amend. If the defendant says nothing about the NOI, go forward, okay? If the defendant says they want an NOI, mail one and tell the judge after the judge grants it. Now we have to sit on our hands for 182 days or 91 days or 154 days, depending on how you read a statute that doesn't cover amendments. Let me go back to that for a second, okay? It doesn't cover amendments. So when you amend and they insist on a notice of intent, somebody's got to tell us how many days you have to wait, because it doesn't cover amendments, okay? Do I have to wait 182, 91, 154?
Mr. Granzotto, you recognize this is not a new party being added case.
Correct.
It's not a kind of a Bush versus Shabahang case in which there's some clarification. This is a case in which the whole thrust of the medical malpractice action has been transformed. It's essentially a new theory.
Correct.
Under those circumstances, why shouldn't the 182 period again begin to be required? Why shouldn't the kind of settlement opportunities and the kind of opportunities to reflect upon the case and consider the case be restarted? What's unfair about that, and what's in fact not implicit in the statute that 180-day period ought to be entitled to the defendant?
Okay. Number one, based on my
I'm not arguing their position. I understand your concerns with their position, but I'm arguing something a little distinctive.
My first response to you is find it in the statute. I have spent 20 years in this court being governed by statutes. And this statute doesn't apply.
What is the point of 182? What is the point or the purpose of a 182-day period in the statute, but to allow the defendants the opportunity to consider and to work on settlements, to reflect on the case, to apprehend what it is the plaintiff is saying? And why are not those purposes exactly the same purposes that ought to apply with the kind of reconstruction of the case that applies in this instant context?
Go back to your decision in Bush. And what Bush says is the purpose of 2912B and the mandatory waiting period, the purpose of it is to resolve the case without formal litigation. Those are this court's exact words. Now, explain to
one
me,
of the purposes.
how is it possible to resolve a case without formal litigation when the case, in this particular case, has been in suit for 2 years? The Kostadinovski Court of Appeals rejected my argument as being in violation of the purpose of 2912B. I disagree. The purpose of 2912B is to settle cases without formal litigation. How can you apply that to a situation in which the parties are in formal litigation?
It's also to alert the defendant, is it not, of what the particular claims being alleged against them are?
Okay, but okay, well, let me say that in the real world of 2912B, the notice of intent and mandatory waiting period is grossly overrated. However, what this court has
What
said—
about the real world of the legislative enactment that we're focused upon?
and that's right. That's why I would refer you to the first sentence of 2912B1, which says, prior to commencing a case.
Isn't that what
let me just say that,
Let me, one more question, please.
Yeah.
Isn't that effectively what's being done here, a recommencement of the lawsuit?
Well, that's an
We're not
interesting
talking
point.
about
It hasn't
some,
been made.
modest, some commas being added here, some sentence being reconfigured there. We're talking about an entirely new claim, one that's tantamount to the commencement of a new action.
You're correct the way this case went down. There's no question about that. My point is that that's not what the statute says. That's my simple point. But on the second point, we are in agreement. If my first argument fails, then the fact is that what Mr. Cook has suggested is what happens in these cases is the plaintiff is forced to file a new NOI and everybody sits around for 6 months while this new NOI accomplishes nothing. Okay, but the suggestion that Mr. Cook has made here is that somehow the plaintiff in this case is not entitled to the benefit of what he says is ridiculous. Because think about what Mr. Cook has done in this case. By acknowledging that that is in fact his position, he has completely undermined the whole idea behind the objection that the defendant originally offered to this amendment. The original objection was this amendment is futile. It's futile because it doesn't include what's in the NOI.
Can I ask you one practical question, please? I appreciate your passion about this. It is an important case. But if this court finds that, yes, there does have to be a new NOI filed in this instant context, how is it that we distinguish what cases require a new NOI as opposed to those cases that ought to be treated more in accord with Cavanagh?
Well, the fact is—
How do we make the distinction?
That's the third level of my argument. I'm a huge proponent of 2301 as a statute that should be done. But quite frankly, the Court of Appeals did not get Bush versus Cavanagh wrong. If in point of fact you overrule the Court of Appeals, you can adopt Mr. Cook's position in this case, and you say it, and you say this, the fact is Bush is, as the Court of Appeals ruled, and it's again my third argument, what the Court of Appeals did in this case was a complete and correct application of Bush, because what Bush was about was a defective NOI, and what the defendants argued in this case was that the original NOI was defective. It was defective because it didn't include those theories that the plaintiff wanted to raise through the amendment process. The argument was exactly the same, and what the Court of Appeals did, I don't think you have to resort to 2301 in this case, but quite frankly, if you're going to say that the Court of Appeals got this wrong, then something's wrong with Bush. But
Thank you,
that's
counsel.
my third level of argument.
Thank you, counsel.
Thank you.
It's a good thing I have rebuttal time. I've never had an argument so focused on me. So the reason I came up originally, it seems like, is because the assertion that I changed the theory. The theory's never changed. The only difference in terms of what I said on appeal and what trial counsel said is I was explaining why Mr. Granzotto was wrong. we both had the same essential point. This plaintiff is forever limited to the only NOI that he ever sent. If he had sent another one, there would have been something else to discuss in the trial court. There wasn't. So defense counsel, who, in case he's going to watch this video, I'll say is not less intelligent than I am, he argued that this plaintiff is limited to the only NOI that he sent. And so since this claim wasn't in that NOI, he can't add it to the complaint. It's futile. Mr. Granzotto also argues, it's sort of this argument of, you need to step in and do what we didn't ask the trial court to do. Well, we're on appeal. You're reviewing not only what the Court of Appeals did, but what the trial court did. And the trial court denied leave to amend, and it's subject to an abuse of discretion standard. And so you have to review whether or not she abused her discretion in saying, no, this is futile, and I'm not going to allow the amendment. Not, should she have stepped in and told the plaintiff to do this, and they all gone back in chambers and worked out how to get this claim in there. That's not the standard. We're doing appellate review, so you review the ruling of the trial court.
Mr. Cook, if you lose on the preservation issue and a new NOI can appropriately be filed in this case, what is your response to Mr. Granzotto on his argument that this is essentially indistinguishable from Shabahang? It's a Shabahang case.
Yeah, there's a huge distinction. The huge distinction is that in Shabahang, the claim was at least alluded to in the notice. It was there. The defendants could have figured it out from it. That's what Bush hung its hat on in saying an amendment can be allowed of this NOI for these defendants because it said based on their sophistication, they could figure out what this plaintiff was going to sue them for.
So why would they require an amendment to the NOI at all in that case if they could figure it out?
To technically, because they did agree that it was deficient in the way that it described it. It didn't go through exactly, I believe it was.
I guess that's the point. It was deficient, and this one is deficient.
Right. I mean, they're both deficient, right? But one at least gave the plaintiff or the defendant some indication of what they're going to be sued for. This one does not. So that's my distinction of Bush, and that's why I say.
But the Court of Appeals here, as I understand it, is just saying, do a new NOI and give them the 182 days, and then proceed with the suit.
So yes, the Court of Appeals remand order was to consider whether or not.
This is a strange one for me because when I read the briefs, it didn't seem as if anyone embraced the Court of Appeals.
That is correct.
Although
the Court of Appeals
at argument today, I take it that your third and final fallback position is the Court of Appeals is right.
Right enough for today.
Yeah.
Right.
Is that about right?
Right. Well, I think part of it too is Mr. Granzotto realizes that he has a preservation problem in terms of arguing for 2301. No one's offered any defense of that analysis being brought up on appeal and applied here.
What would you have had the plaintiff do in this case? File
this
an
case,
NOI before even moving to amend the complaint?
Yes. The testimony shows that he knew about the claim back in July 2015. If he had sent an NOI then, he has no problem when he moves to.
Wouldn't you come into court and say we need to stay of proceedings for 182 days? And
it depends on the
court
court.
Would say, why would we need to stay of proceedings? Because they're going to amend. Well, no, I'm not going to let them amend. They have to ask me to amend. They can't amend on their own. Isn't it more prudent to go into court, ask for an amendment? And if the amendment's granted, then if the defendant wants an NOI, we give them the NOI?
No, because the notice comes first. And so in that situation, you explain to the trial court judge, this defendant has a right to 182 days to consider this claim. He can waive that right if you'd like to, but he has that right to a judge. In terms of whether or not the judge needs to enter
And that can't be
stay,
said at the time where you move to amend the complaint.
Sorry?
And that can't be said at the time you move to amend the complaint. Isn't that essentially what the Court of Appeals has said to do here?
So whether or not they could send the NOI and the next week move to amend the complaint and say, Judge, once this 182 days goes, then we want to amend the complaint. I wouldn't have a problem with that.
If you file a motion, you have to file a motion to amend the complaint, right? I mean, you can't just go and file the amended complaint. So in filing the motion, are you not saying, allow me to do this, and then I'll file the complaint, I'll file the NOI, we'll do it the way that it's supposed to? Would their motion to amend the complaint encompass them doing what is necessary in order to do that, which would include amending or filing a new NOI?
Right. So that didn't happen here. I guess practically speaking, if the ruling comes out in favor of my argument that they do need to send the NOI, I would suspect the reality is they would send the NOI and then file the motion and say, we've sent the NOI.
Or attach the NOI and the amended complaint to the motion to amend.
Sorry?
I mean, would you file a motion to amend and attach your proposed NOI and your proposed amended complaint?
I don't think you need to attach a proposed NOI at that point. You just send the NOI. You need no leave of court, you need no permission. You can just send the NOI. You actually don't file it in court, right? You just mail it to
Right.
the defendant.
I haven't heard clearly from you why you think this is not an ordinary Shabahang case. I think an argument can be made to that, to that effect, but is that your argument?
So I don't think Shabahang and the statute 2301 apply for two reasons. The first is that they never sent the notice so they couldn't commence an action on this claim. So under Boot, Driver, Tyra, 2301 doesn't come in. The second reason is that under Bush, they said that the first threshold to get in the door is that it has to be in furtherance of justice. And there, Bush explained it was in furtherance of justice to amend the NOI if you've at least given the defendant some inkling of what they might be sued for. That didn't happen here. So 2301 can't apply in that situation.
Why was this less effective in communicating to the defendants what the gravamen of the suit was in this case, what its thrust was, what they needed to do in preparation? What was less effective in this case than what we had in Shabahang?
There was a complete, and there's no dispute about this, that the theory in the NOI has nothing to do with the theory of the standard of care, what should have been done, and how it caused this gentleman's injury. There's no inkling of it in there. In the original NOI, it was all about detecting whether a clot was in the arterial tree, that clot breaking loose because they used a certain instrument, and that causing a stroke. The new theory has nothing to do with the clot. All it is about is during the surgery, the blood pressure dropped to a certain level, you should have noticed and transfused, you didn't. As a result, they deprived the brain of oxygen and other nutrients, and that caused a stroke. The two are irreconcilable. There's no doctor who could look at this NOI and draw out of it, the first one, out of it that he would be sued for this hypotension transfusion.
So it's just something to do with the original NOI versus nothing at all to do with the original NOI distinction.
Right.
And how do we determine that again? Where's the line drawn? This is not a black and white kind of issue, is it? It's a.
Well, I think in this case it clearly is, because the parties don't disagree that the claims are very different. I think the line that you draw is if it's a new claim, meaning if you're asserting a new standard of care, something else that should have been done, or a new causation theory, right? A different way of connecting what you did to this gentleman's injury, then it's a new claim. And that's the distinction in the line that's been drawn. Bush versus Shabahang, the opinion there said that they came close enough to letting the defendants know what the standard breach and causation theories were. They just didn't spell them out as clear as they should have.
Thank you, counsel. The case will be submitted.
Thank you.
That completes the call. We will return at 1:15.